Welcome and good afternoon to those of our guests who've already joined us. I'm just going to pause for about one more minute because we still have attendees joining. So I'm just going to pause for about one more minute to let people join and then kick things off. Okay, we may have a few people still joining, but it's time now to get things moving. So let me begin by introducing myself. My name is Anirudh Mathur, and I'm a barrister at Matrix Chambers, specializing in international human rights law. I'd like to start by handing over to Professor Philip Leach, who's a member of Matrix Chambers and the convener and organizer of this series. Philip, over to you.
Hello, thanks very much indeed, and welcome to everyone this afternoon to this fourth in our series of webinars on international human rights litigation, organised by Matrix with Bonavero Institute of Human Rights at Oxford University with Professor Başak Çalı, who's co-convened these. And we've been looking in this series at cutting edge human rights issues in relation to litigation at the regional bodies and also at the UN treaty bodies and in other contexts too. And the recordings of the previous webinars are available, and Charlotte will put a link in the chat if you want to have a look at those or listen to those recordings. Our focus today is on human rights remedies. We're going to look at some trends and some trajectories in different contexts, and Anirudh will introduce the speakers. Just by way of introduction, though, I'm going to speak for no more than 5 minutes and say a few introductory words about the European Court and the policy and practice of the European Court of Human Rights. And it's a critical question, isn't it? Redress. What do applicants want? What are they trying to achieve, and what is it feasible to get? It's a fundamental question for litigants and those advising them. And I want to say a few words about the direction of travel of the European Court, as I've said. And you will all know that the essential model of the European Court is one of a declaratory approach. You'll get a declaratory judgment, and they can and often do award compensation, and that is still a core approach to court, but in many ways it has branched out quite significantly in recent years. And I just want to briefly look at the ways it's been doing that. One of the ways is actually at the interlocutory stage through interim measures that we discussed in one of the webinars, but it is, we now know, of course, it's not just a matter of the court ordering a state not to deport someone, but the court can also and has done this, ordered a state to not to liquidate an NGO, in the Russian case, Russian situation, not to take over or take on the a journalist's sources, as a case in Ukraine. And other examples in Poland of taking measures to ensure the independence of the judiciary in Poland. And that's just interim measures. Turning to merits, again, the court has developed a practice in terms of individual measures, individual redress, so orders directly for the benefit of the applicants, for the litigants, and to make very specific directions, very clear and particular directions. We've seen the court order the restitution of property. We've seen the court order retrials in certainly in the criminal context, and very rarely in the civil context. We've seen the court order the release of individuals unlawfully detained, and usually those orders are complied with. I would add that in fact Professor Çalı and I are acting for Osman Kavala at the moment, a case against Turkey, and the court has ordered his release twice, and the Turkish government are refusing to release him. So the issue of redress is, as the example shows, very closely linked to the question of implementation, which we may also come on to. Other cases, the courts ordered the reinstatement of a judge who was sort of politically dismissed in Ukraine. They've ordered this. The courts ordered the disclosure of information, and for a family relation to be made, family contact to be maintained. So we know that this is possible. It's still pretty rare, and it's quite hard to define when and in what circumstances the court will sort of break out in this way. But it is, it's a much broader practice, and I think offers a lot of potential. Then, if you turn to finally, in terms of what I'm going to say, turn to general measures, and again the court making much wider orders, and it's partly out of necessity because of the sheer volume of cases that the courts received and the Russians coming back to the court. And we've seen the court develop the pilot judgment process starting 20 years ago, in which the court identifies a systemic problem, diagnoses the problem, but then goes further and requires a change in law, a change in practice, and so on. It won't direct exactly how the law should be changed, but it will do so. And we've seen the pilot judgment process. It started in a Polish case, Broniowski case, about the restitution of property, in cases reaching back to post-Second World War. But it's made similar directions in cases of excessive length of domestic proceedings, in relation to very poor prison conditions, in relation to the non-enforcement of domestic court judgments, and other issues. And of course, in the UK, we've seen it used in relation to prisoner voting rights. Now, those cases, it's fair to say, have had mixed results. In some of the situations, states have acted pretty quickly and have reformed the law and produced measurable change, but that's not been the case in certainly in every example. Those cases are pretty rare now. What's more common are Article 46 judgments, so not fully fledged pilot judgments, but sometimes known as quasi-pilot judgments, where the court relies on Article 46 and still makes a direction in relation to a systemic problem. Those are rather more common than pilot judgments now. So I think, just to finish, I do think this question of redress is also closely linked to the question of implementation. We have problems of implementation across all systems, and all our speakers will refer to that. In Europe, we've seen the use of infringement proceedings in two cases now, Mammadov and the Kavala case I mentioned. It hasn't been successful for Kavala, but it was for Mammadov. And we've got a new process that's never been used, the complementary joint procedure, where there is a failure in implementation. So we'll see in future years whether that's going to be used and whether it will make a difference. So we know the court's got these powers. It's not entirely clear, I think, in what circumstances they are or will be used, but I think there's great room for creativity. And Anirudh, with that, I'll leave it there and hand back to you. Thank you very much.
Thank you, Philip, for that very, very insightful summary of the situation before Strasbourg. Just before I go over to our speakers, there's one point of housekeeping, which is that there will be time for questions. So keep your ears pricked and ready, but please do save your questions for the end. They can be written in the chat box. It's my pleasure today to introduce first Professor Clara Sandoval, I should say Honorary Professor Clara Sandoval at Essex University, who is the Director of programs, the Global Survivors Fund, and an expert on various aspects of redress in international human rights. She's the co-author of a book on reparations for victims of armed conflicts, as well as on doctrine, practice, and advocacy in the inter-American human rights system. And I'm also delighted to introduce Floris Tan. Floris is a senior legal associate with the Climate Litigation Network, where he supports national organizations who are bringing framework climate cases against their governments. He specializes in human rights law and the implementation of human rights arguments in climate litigation, and holds a PhD in international law from Leiden University. Very interestingly, he previously worked at the International Law Division of the Ministry of Foreign Affairs of the Netherlands, so has that very recent and direct experience of both sides of many of these cases. And the Climate Litigation Network, where he's now based, is a not-for-profit foundation that works with partners around the world to bring groundbreaking litigation against high-emitting actors. So with those two headline introductions, I'd like to hand over first, please, to Honorary Professor Sandoval to begin with her remarks.
Thank you so much, Anirudh, for the invitation, and to Professor Philip Leach as well. It's a pleasure for me to be here with you. Just to put a bit more context to who I am. So yes, I've been an academic for many years in my life, but I have been also a practitioner. I have litigated cases before the Inter-American System of Human Rights, and have always found as a key goal in my life to ensure reparation for victims. If there is a reason to speak about human rights, is because victims have a right to reparation. That's where they really see the worth of it. And I've worked on it not only in litigation, but also in transitional justice processes, ensuring that victims can have access to reparation through domestic reparation programs. So my views come not only as a litigant and academic, but also as a person that has had to grapple with the question, how do we do to really ensure reparation through different types of remedies, even if they are not judicial, like administrative remedies. So let me just contextualize the Inter-American system a little bit for you, because there are particular nuances that make the system very special when we think about the trajectory, what has been achieved, etc. We have a system, an Inter-American Commission and Inter-American Court, that have been joined by others, litigants, civil society organizations, victims, survivors, and they have given life to an amazing ecosystem that I consider incredibly prone to reparation. This system wouldn't be possible without the ecosystem. You need clearly a multi-stakeholder approach to enable reparation, and that is true of courts as it is true of administrative remedies. And the success of the Inter-American system is in part due to the ecosystem of factors that have been able to link together. They have been galvanizing action through decades of activism that has really permeated the work of the Commission and of the Court, and that allowed it to really come up with reparations that are, in my view, a key another element, holistic, because they have not only restricted their work to providing compensation, as many courts do, but also to considering how do we grapple with these very serious violations in the Americas region. So understanding that there are not only 5 forms of reparation, as we often think in human rights litigation, so compensation, restitution, rehabilitation, satisfaction, and guarantees of non-repetition, but also others that have become emblematic in the system, such as the obligation to investigate, prosecute, and punish perpetrators, but also, for example, finding the whereabouts of the beloved ones, the many disappeared, for example, in the region, or actually ensuring, first of all, that the rights that have been violated can actually be exercised by the victims. No? So all of these are forms of reparation that the system works on a daily basis. And the system has also nicely dealt with guarantees of non-repetition that I think are absolutely crucial when we are thinking about a strategic litigation. How do we tackle the root causes of conflict or repression? And this has been the history of the system, trying to grapple with these different forms of reparation. And this is true of cases involving, gross human rights violations, passing from countries like Argentina, Chile, Colombia, Guatemala, Mexico, to other types of cases that are, for example, related to indigenous rights. And here you go from Paraguay to, for example, Peru, to Ecuador, Brazil, you name it, or cases involving issues related to gender. And maybe this is the other point I will love to make, and is that the system, the ecosystem, has really developed a great gender, ethnic, and environmental sensitivity that is also now taking shape through the different forms of reparation it awards. And again, I want to highlight, this is the work of a system, no? So it's not only the court or the commission sitting and coming up with great views on what reparations should come. This is actually being leveraged on a daily basis by the litigants, by the testimonies provided by the victims, by the experts that are brought to the court or the commission to explain what is going on, the harms, provide the evidence, provide expert opinions, the amici that are appearing before the system in order to give life to all of this. Now, another thing that is very important is to see, and this is, I think, a nice trajectory in the work of the Inter-American system, is to see how while the system began to grant and order various measures of reparation, if you compared the drafting of those measures 10, 15 years ago to the ones now, what you see is that they have gained greater specificity. A specificity in the sense that they are telling the state more clearly what the court or the commission want, particularly the court, establishing, for example, what the state needs to do, in what time, with which reports, etc., in order to really facilitate compliance, because the issue of how to ensure implementation is a major one the court particularly, but also the commission is having to grapple with. But in the process of getting the orders to have more specificity, it is fascinating to see the trajectory too in relation to how much deference the court is giving to states, no? So I think during the last decade, what you've seen is a court trying to grapple with that question, acknowledging that there needs to be subsidiarity, that there are things it cannot do, but also not going the way of the European Court of Human Rights, that is not just, let's leave it declaratory for the most of it, but actually telling the state what it can actually say. And I think an interesting element you begin to see here is the acknowledgement of the court that it can really tell the state, you need to do this. But here in this area, for example, as happens with cases related to the environment, and maybe Floris, you can talk a bit about that, what you begin to see is a court that acknowledges that it doesn't know it all, and that it can actually not tell the state every single detail of how a reparation order on environmental issues has to be done, no? So for example, I was looking at the case of Peru that was decided just 2 years ago, which I think is incredibly emblematic, and is the case that concerns the Oroya, the Oroya metallurgical complex. And I love the way the forms of reparation are crafted, because it says, I give the state the obligation, for example, to put in place a baseline assessment to determine the status of air, soil, and water pollution. I'm not gonna just tell the state this is the way it is happening, no? I acknowledge I cannot do that, but you have the obligation to do it, and you are going to do it in the following way. So it's recognizing it doesn't know it all, it's recognizing you can do certain things, but I can tell you what to do. So I really welcome this balancing transition in which the court is finding itself nowadays. But the other point I would like to say is the impact the system has had, and this is both the commission and the court, on the lives of victims is clearly notorious. And I would like to hear what your views are on this, for example, in relation to the European system, because in the system you really see something that Helen Duffy calls like the transformation from victim to survivor to, claimant to really an activist. And this is a major impact coming out actually from the reparation too, and from the whole litigation process. And I think this is something to be rescued, because for many of these victims, they have never been heard, they've never been dignified, and the way the system is creating spaces for them to appear are ways in which the system is already repairing them. No, so I think this is also an area we need to fully explore. But the system has also, the trajectory of the system has also allowed the system to have an impact at the national level, ensuring that policies, laws, etc., are transformed. No, so the goal has not always been let's achieve justice and reparation for the victims we have in front of us, because it's clear that in many of the cases that arrive to the Inter-American Court, there is a structural issue. And what the court has tried to do by crafting the reparations is to trigger action at the national level so that you can actually come up with national systems that can really respond to this. And I've seen a very interesting balancing exercise, for example, between the award of court order reparations at the system and domestic reparation programs, how the court is trying to trigger action of those major programs set up at the national level in cases like Colombia, like Peru, etc., so that they can really, really do things. But I also welcome from the system that the system has had to grapple with the question of implementation. Of course, being a system that really is taking reparation very seriously, you can imagine that it is also struggling to ensure implementation, because not always the decisions it has taken have gone through the prism of what is feasible, whether it is adequate or not to order this or that. At times, the excitement has also taken over, particularly at the beginning. And I think that it has also come up with solutions. And I think the Inter-American Court has today the most compelling monitoring system of compliance at the international level. And I think we have quite a lot to learn about it. And this is a system that combines different things from a unit that is monitoring compliance that it didn't have. So in contrast with the European system, where you have the Committee of Ministers monitoring execution of judgments, here is the court that has that power. And for many years, it was only the court. Now, at least since 2015, there is a unit. And currently, just to give you some numbers, by 2024, the court was monitoring 322 judgments. And you might say, oh, that's tiny, Clara, compared with the European system. But in 322 judgments, the court has been monitoring 1,755 measures of reparation, which are each of them incredibly complex. Compensation is often paid. That's not the problem. The problem is the difficult measures, like in the Oroja case, where you start dealing with the environment and guarantees of non-repetition. So monitoring 1,655 measures requires knowledge, time, but also creative thinking about how to move the political, not only the legal. And I think the court is trying to do that with that unit and also with the judges. So it issues orders, it holds hearings of different type. It also does on-site visits. It goes to the places, and I've seen it in with victims, no, that have said to me, Plan de Sanchez, and this is one I love. When I visited Plan de Sanchez, the victim said to me, we won the case, and we won it in 2005, I think it was. And they're still waiting for the full reparation, but things have happened in that case. But it took a visit of the court to trigger action. So the court went to the village and visited them and saw with its eyes what was going on. These things make really a major difference in triggering compliance. But the court not only does the hearings and monitors compliance with on-site visits, but it also can issue orders, and through the orders it issues, it comes up with new nuances about how implementation has to happen. So if you want to have a clear view of implementation in the system, you can not only look at the judgment, you really need to look at the orders, because they keep spelling out what else needs to be done, so that it really, really happens. And I know I'm running out of time, but I just want to say three quick things, if I am allowed. Is one, I think we as litigants need to do much better in understanding what victims need, what victims want, so that is truly reflected on our requests on reparations. we don't always listen to victims. And I think my work says that participation of victims is crucial to ensure implementation. So that starts right from moment zero of a case. The second thing is litigants. As litigants, we really need to think about the structural dimensions of the case and bring on board quite early on key actors, including from other disciplines that could really inform our work and the crafting of these measures, so that in a very multi-stakeholder approach, these measures can be thought with the view of ensuring implementation, because if not, these things are going to stay on the paper. I think that we need to also look for more rigorous orders that continue to give a space to states to maneuver, but that clearly establish the what is needed. I think that's something that we need to continue working on. I think I will leave it there for the moment, Anidur.
Thank you, Professor. Thank you for your very detailed and insightful evaluation. There are many things there applicable to the inter-American context, very interesting in that context, but of broader application. I'm thinking, for example, of the African system, the African Commission, and similar things done by the African Commission and African Court in respect of third-generation solidarity rights and reparations there. Just a reminder to keep your questions coming in the Q&A box, and then we can have them all there and ask them at the end. But just before that, I turn over now to Floris. Floris, please go ahead.
Thank you very much. And thank you very much for having me. It's really a pleasure to be here with you and to talk about remedies. And I was asked to talk about remedies in climate change litigation. So what I would like to do is to first say something about the types of remedies that there are in climate change cases. To then, this webinar series is about international human rights litigation, so I then want to talk a little bit about European Convention on Human Rights System, and especially about the Klimaatsenioringen judgment. And then finally, if I have time, I want to link that back to domestic litigation and the questions this raises. So maybe a first thing to mention, when I talk about climate change litigation, what I mean is framework cases. So cases where someone is challenging their government's overall mitigation efforts. So where they're saying emissions reduction targets aren't sufficiently ambitious, or where they are saying that the existing targets aren't being implemented. And in those types of cases, when you win, what you ultimately want to achieve is, of course, further emissions reductions. That's the goal that you have. And in that light, there are sort of three types of remedies that you can ask for and that you can obtain in court. And the first one, which is the most concrete, is an injunction, where a court might order a specific reduction target that the state has to meet by a specific date. And because it may be viewed as on issues of separation of powers, but it has happened in courts in the Netherlands and in Belgium, where in the Urgenda and Klimaatzaak cases, courts have ordered states to achieve specific reduction targets. Then the second category of cases, and this is what Professor Sandoval also alluded to, is where courts order due diligence type of remedies, where they don't order a specific reduction target, but they say to the government, you have to go back and do your homework. You have to go back and, based on best available science, you have to quantify your carbon budget and align your reduction pathways with that budget, where courts therefore don't go into as much detail, but they put it back to the governments to do their work. And they're a bit more deferential to the states. And then the final category is declaratory relief, where courts don't go beyond a finding of breach of human rights or of tort law and don't order any specific remedy. And these three categories of remedies, those of course feed into your legal strategy. So What do you ask for? And what do you think a judge is actually comfortable ordering? And that may depend on the jurisdiction where you're litigating. And that's what I want to come to next. So I want to talk about the European Convention on Human Rights system for a little bit, and then I'll talk about domestic cases. So on the European Convention on Human Rights, there's been one big climate case that was handed down on the merits, and that was the Klimaatsenuringen case. And I think, as was touched on already, the European Court of Human Rights normally only grants declaratory relief. It normally doesn't indicate what states need to do to implement the judgment. And in the convention system, it leaves that up to the respondent state under supervision of the Committee of Ministers of the Council of Europe. And I think this implementation process is not very well known at all, but at the same time, it's quite instrumental to defining what states need to do to remedy a violation. Because if the court doesn't explicitly say it, then it will have to flow from the implementation process and the Committee of Ministers supervision over that process, what the judgment actually required. And I feel like this is often overlooked, I think, when we study law, but also when we teach law. The implementation process is often a little bit of a black box, and we stop sort of at the landmark judgment where you have your champagne moment in court when you win, and then the implementation process is not that well known. So moving to the Klimaatsenuringen judgment, I think most of you will be familiar, but just really briefly, it was a case about Swiss senior women challenging Switzerland's climate ambitions. And the court went on to find violations of Articles 8 and 6 of the Convention. And on a really basic level, the court found that there is a right to be protected against climate change, and that there is an obligation for states to take measures capable of mitigating the adverse effects of climate change. And then it went on to specify a number of specific obligations which flow from that obligations. And the most important one, I would say, is that states have to quantify a carbon budget. But after the judgment was handed down, it turned out that there was still quite a bit of discussion on the interpretation of that requirement, because there were those, and among them was Switzerland, as I'll touch on, which said that this is just a tick-the-box procedural requirement where as long as the state somehow quantifies a budget, it's fine. And then there are those in civil society, and CLN is among those, who say, well, there is real substance to it, and what you actually have to do is quantify your budget as your fair share of the remaining global carbon budget. And because the court didn't order any specific remedies other than just satisfaction, that was left to the implementation process, and it was left to Switzerland and the Committee of Ministers to figure out what this requirement entailed exactly. And so I want to tell you a little bit about the implementation process here and what came out of that. And there was a lot at stake, because after the judgment, both houses of Swiss Parliament adopted declarations which outright rejected the judgment, that said it encroached on Swiss sovereignty and that the court should go back and study its own history to better understand the competence that it actually has. And then Swiss government submitted an action report saying that the Committee of Ministers could close supervision over the judgment because actually it didn't really need to do anything to implement the judgment and everything was fine. So because the court didn't specify the remedies that were required, the government tried to take that space and say, well, we actually don't need to do anything. So what we were faced with was a really strong judgment, but at a real risk of being watered down in the implementation process. Because if it turned out that the intergovernmental body of the Committee of Ministers interpreted this judgment in a really restrictive way, then there was hardly anything left of the judgment. So that was sort of the situation that we were faced with. And in that context, civil society formed a coalition. CLN was part of that, and Greenpeace International was leading those efforts. And we tried to look for ways to influence the supervision process. And we essentially identified 3 ways of doing that. One is the only formal way that there is, and that is to submit a Rule 9 submission, where NGOs can provide their views on what a judgment requires and why the respondent continues to fall short. And then there are 2 more informal avenues, which is to get in contact with the execution department of the Council of Europe, where essentially there are civil servants who prepare the Committee of Ministers meetings. They do the first analysis of what the judgment requires. They come up with the draft decisions for the Committee of Ministers, and so their work forms the basis for the debate in the Committee of Ministers. And then the final avenue is trying to get in touch with state representatives who actually sit on the Committee of Ministers. So one of the things that we did was we took part in a webinar where we were able to lay out our interpretation of the judgment as requiring a fair share carbon budget, and where we knew that there were a lot of Council of Europe officials and state representatives attending that webinar, so that way you get your thinking out there. And then we also, of course, submitted a Rule 9 submission. And I mean, Switzerland had, where we pointed out that all that Switzerland was doing was re-arguing points that it had already made and lost during the proceedings. But where we also submitted new evidence showing that the climate policies that Switzerland had, that those would amount to it taking up twice the carbon budget that it was entitled to, and that the fair share carbon budget that it actually had would run out in 2030 at the latest. And this was quite successful in that the Committee of Ministers, when it handed down its decision, it rejected the Swiss request to close supervision, and it asked Switzerland to provide more information on how its climate policies complied with the judgment, but also on the methodology it had used to come up with those climate policies. And that really aligns with the NGO position that this isn't a mere tick the box. We define a carbon budget somehow. No, it's a substantive requirement, and you have to show that your methodology actually matches up with human rights requirements. So the point, I guess, that I'm arriving at here is that even though the European Court of Human Rights often hands down a declaratory judgment, the substance then of the remedies that are required, well, what's required to remedy the human rights violation is continued on what comes after the judgment in the Committee of Ministers supervision process. And then moving on now to cases at domestic level, and this is where I'll end. As I mentioned, the European Convention sets a really strong framework for legal obligations, and then the court also stressed the key role for domestic courts in climate litigation. So it stressed the principle of subsidiarity, that domestic courts always have to rule on these issues first and European courts only after. And then, of course, the right to an effective remedy at national level under Article 13 of the Convention. But then if you look at domestic level, there is a really wide variation in what domestic courts are actually willing to order in climate change cases. So I just want to mention 2 examples of really recent cases where the Swedish Supreme Court at the start of this year handed down a judgment saying that the separation of powers does not permit Swedish courts to order the state to adopt legislation or targets or to take any measures, and that it could order declaratory judgments only, but that even those declaratory judgments may not imply in any way that the court is compelling the state to take a certain action. So that's sort of one end of the spectrum. And then the Portuguese Supreme Court, end of last year, handed down a judgment saying claims in climate cases may not be vague or overly generic. Now, they must be specific in terms of reduction percentages that are asked and in terms of the measures taken. So you have these 2 Supreme Courts on complete opposite ends of the spectrum, where one says anything you ask beyond declaratory relief is not admissible. And then on the other end of the spectrum, you have the Portuguese court saying, well, if you're vague, if you don't ask anything specific, then it's not admissible. So the type of remedy sought in climate litigation is then dependent on the jurisdiction where you're seeking it. But at the same time, human rights require an effective remedy. And in the climate change context, arguably, that requires concrete emissions reductions. But that doesn't always line up well, the jurisdictional hurdles and then the requirements under human rights law. And that is one of the big challenges of climate litigation at the moment. So I'll leave it there for now. Thank you.
Thank you, Floris, for that very, very interesting overview of your work and the complexities and the various contexts that you were discussing. I think we have a good time now for questions. So let me go to the question box. The first question is from, and I want your apologies in advance for any mispronunciation, from Morgan Knoll, who asks, and I suspect this is a question directed primarily for you, Professor Sandoval, but Floris, please do join in. What enforcement mechanisms are most effective in ensuring compliance with inter-American court reparations, especially in states with weak institutions or ongoing political resistance? So that's a question for you, please, Clara, and to all the listeners, please do keep your questions coming in.
Okay, no, I will go back there to the forms or the tools the court is actually using, because I think it's a mixture between what tool to use, for example, a hearing, an on-site visit, and this would depend on partly what the court thinks needs to be done, but also what the parties to the case will ask the court to do, no? But a lot of the political is what is really triggering action at the national level. So being able to sit down in an informal manner, the court with the state and key state actors. For example, when these hearings happen at the national level, because it's not always in Costa Rica, at times the judges travel to another jurisdiction, that is the jurisdiction that is in question here. They have the opportunity to talk not only to the persons representing the Ministry of Foreign Affairs, but actually to talk, for example, to the Ministry of Health or to the Ministry of the Environment, and to bring really the people that can mobilize action on implementation. So that is a major game changer, when you can bring not only litigants, but those that really work on a daily basis on making that possible at the national level. When you create possibilities to bring them closer, the litigants, the victims, and the state. So these things have really worked in enabling the movement of investigations at the national level, or, for example, in enabling the fulfillment of rehabilitation as a form of reparation at the national level. Yeah, there are states in the Americas. You will be. This is also a number that might be interesting to you. 55 cases have been completely closed in the Americas involving different types of measures, and that's quite interesting. No, in a region that you would say has weak institutions, etc. It's actually quite remarkable with the type of measures I was mentioning before. And I think it comes down to that, to the ability of the court to stop sometimes being so legalistic and thinking more strategically about how to trigger action and bring others. So I go back to the multi-stakeholder approach. The more you can reach out to those that can make a difference at the national level, as a litigant, as the court, the better it will go for the case. And also thinking in advance on feasibility. What is feasible to request the court? What are we likely to get? What are we likely to ensure is implemented? In fairness, of course, in fairness. But I think if you think all the time about these issues, it is possible to come up with nice action plans like the ones that you have in Europe. I think that's also something important, very important, as you were saying, Floris. No, this dialogue, this constant dialogue is really showing results.
And can I actually ask you a question, Floris, on the back of what Professor Sandoval just said, which is Climate Litigation Network has this quite broad mandate, and it deals with domestic litigation before several courts, but also before supranational courts. What has your experience been of concrete domestic cases seeking to enforce a finding made by a supranational court, be that Strasbourg or any other supranational court or body, such as a UN treaty body? Is thinking in terms of the ecosystem that Clara is talking about, has Climate Litigation Network been able to use that strategy to good effect?
Thank you for that question. Honestly, I feel like there may not be that much practice yet in terms of climate litigation because there haven't been that many judgments or findings yet at the international level. So what we see now in Europe is a new wave of climate litigation based on the Klimatsynringen judgment. And there's still several cases pending before the European Court of Human Rights as well. But what I expect is that once the Inter-American Court of Human Rights hands down its advisory opinion on human rights and climate change, and once the International Court of Justice hands down its advisory opinion on climate change, which for an important part also relates to human rights, I would expect that this will play a much more prominent role in the cases pending at domestic level, where we will try to implement what's in these findings by international courts and bodies into domestic litigation. And they will also have to inform what you can obtain in terms of remedies, but I find it difficult to say what that will be before having the chance to read those advisory opinions. What I can say is that now, based on Klimatsynringen, there are many cases in Europe pending who are invoking that judgment and who are pushing for an interpretation of that judgment where states have to quantify their fair share carbon budgets, and where a lot of inspiration is drawn from what other jurisdictions are doing. And this is how Climate Litigation Network started in the first place, that based on the Urgenda judgment in the Netherlands, local partners came to us asking us for how this happened and whether they could replicate that type of case in their own jurisdiction. And in climate litigation, it turns out that domestic courts are really interested in how other courts in other jurisdictions have dealt with these same issues of causality, of attribution, of separation of powers, because they're the same everywhere. So there's a real inspiration source there.
Thank you. And there's one more question which would be interesting to hear both of your thoughts on, and it's asked by a couple of people. It's to do with the standing of applicants and an issue, and I think it's one that arises particularly acutely in the context of more complex reparations and more complex rights, including solidarity rights. It's this: could reparations in this context include collective rights, such as collective land rights, access to clean water, or sustainable resource control by women's cooperatives? And well, let me ask you that first, and then there's a follow-up question that I'd be interested to get your thoughts on once you've had a chance to consider that.
Should I go first?
Yes, please. Yeah.
Okay, no, well, the thing is that the standing in the Americas is a little bit different to Europe because we have the Commission. So basically we have an actio popularis before the Inter-American Commission. So anyone can actually bring a complaint, any person, group of person, or a civil society organization registered in the region can actually bring a complaint, even if they are not the victim. No, so I think this is a bit of a difference with the European system. And then once the case is sent to the court, you have identifiable or clear victims. So I think that sorts it out. But in relation to the second part of the question, I think that it's important to say that the Inter-American system, both the Commission and the court, have been quite keen to protect the right to collective land, access to clean water, sustainable resources, We have fascinating cases from La Cojonat to the Oroya case, to the Uwa case, dealing particularly with this very collective dimension, not only in relation to indigenous peoples, but for example, in Oroya, this is a community, no, that was really being impacted by pollution, by really toxic pollution. And it's 80 people, 80 victims identified in the case. So I think the system has that approach and has also the gender approach. And indeed, in La Oroya, some of the reparation measures are not only about gender, are also about particular groups of people, no? So specific measures in relation to children, to the elderly, to women. You begin to see the distinctions, the subtle distinctions that the court is ready to do. But the court has, as I said at the beginning, a very strong jurisprudence on the protection of the rights of women. And I draw your attention, there is a major hearing this week, tomorrow actually, before the Inter-American Court of Human Rights, in the case, forced sterilization case against Peru, where what is in discussion is precisely the lack of, investigation, but also reparation given by the Peruvian government for the alleged forced sterilization of more than 7,000 women during the Fujimori period. And I think we need to keep an eye on that judgment, because the forms of reparation that will be awarded are going to be first in the world in terms of reproductive violence, but are also going to be incredibly crafted with a gender tone.
And Floris?
Yes, thank you. Firstly, on victim status, as you will know, based on this question, in Klimaat the court opened up the door when it comes to associations, as long as they are representative of a group of individuals who are especially affected by the adverse consequences of climate change. And then for individual applicants, it came up with an extra high threshold of victim status. So I suppose that, I mean, when an association is litigating a case like this in the European system, then it will be representative of a certain group of people. At the same time, as we touched on, the type of relief that the European orders is usually declaratory. So it won't go into these specific issues when it comes to reparations for certain groups of peoples. At the same time, in the implementation process, that might, of course, play a role. And then when it comes to individual victims bringing a case, they will need to show that they are themselves especially affected. But at the same time, they may, of course, be representative of a larger group. So, for instance, there is at the moment a case pending against Austria by someone who is suffering from multiple sclerosis and Uthoff syndrome, which means that as outside temperature rises and his body temperature rises, his symptoms of paralysis also increase. So he directly suffers from the consequences of climate change, because every additional hot day means that he can't leave the house, because otherwise he will be paralyzed. So arguably, I would say he definitely meets this higher victim status threshold. I mean, if he doesn't, then no one does, most likely. And although this is an individual case about him, he is, of course, representative of a much larger group of people who suffer from the same illness. So I would say that in this way, the interests of larger groups are represented. Finally, when it comes to collective rights, I don't think the European Convention on Human Rights has a large track record of protecting those rights very well. At the same time, there is, at the moment, a process going on in relation to the right to a clean, healthy, and sustainable environment, where the Council of Europe is looking at whether they need to adopt a new legal instrument and whether that should be a protocol to the European Convention on Human Rights. And that right is arguably a collective right. So that could be sort of groundbreaking for these types of issues, I would say.
This is a question, I think, for you, Professor Sandoval. Given what you said about the capacity of the court to deal with complex collective rights in these ways, What would you say to skeptics or critics who think that courts are generally, and supranational courts particularly, are ill-equipped to deal with the issues of distributive justice in collective remedies? So we see that very often in the context of mass environmental damage or other forms of mass atrocity, where there's some form of collective redress mechanism that needs to be set up. But it's very difficult for lawyers, let alone courts, to navigate what a just system of that kind looks like. And if they're really forced to end up leaving things to the state, is that something that they should be trespassing on at all?
Yeah, I think that once a case arrives to a court, it arrives for a reason. So it means that the state has failed to take action when it had the opportunity to act, no? And that includes on issues related to distributive justice. So I think the court cannot just simply say, I defer it all to you, because it has a judicial role to play, and it's to decide whether the rights have been violated or not, and the remedies under international law are clear. No, I don't think it is trespassing. I think that it's doing its role, while still acknowledging that a court is not going to resolve social issues of inequalities, no? So that you can come up with various forms of reparation, and they are important as they are, but they are not going to fully transform reality. You need other actors, you need the ecosystem, you need other types of intervention in parallel to ensure that they stick, no? It's about that. You trigger, I think the key contribution of courts in this area is to trigger the change that then others will be able to continue to build on. But courts cannot and should not renounce that power, because that power has been given to them by institutions, by states. No, so why to give it up when they are called to exercise it? I don't think they are trespassing at all.
Thank you both very much. I'm conscious of the time, and I'd like to thank you both sincerely for joining us and sharing your expertise with us today. It's been a very, very fascinating talk and a very fascinating end to a brilliant series put on by Professor Leach. Just before handing over to him for the final word, I'd like to remind all our guests that if you look in the chat box, you can find recordings available for the first 3 sessions, just in case you missed any of those, and the contact details, the web links and contact details for both our speakers is also in the chat box in case anybody wanted to carry on the conversation or ask something they weren't able to now. I'm sure that both speakers would be very happy to engage with that. So my thanks again, and let me hand over now to Philip.
Thank you very much, and Floris and Clara, thank you so much for a fascinating discussion. It was so interesting to hear and to draw connections and draw. I was struck, Clara, by your discussion or your explanation of how the presence of the court when it's monitoring implementation is important. The presence in country. It took me back to the time long ago when the European Court used to do fact-finding hearings, and I was involved in some of those in the Turkish context. And you can say the same thing for the Kurdish applicants, and they were Kurdish, to be there in Turkey with an international court, to be heard by judges for the first time. Was extraordinary. So I think that that point is very well made. In terms of implementation, we don't have that in the European system. So that there's a bit broader. And I think for both of you talked about the importance of connecting international litigation with domestic litigation, and I think you're absolutely right to do that. And I think as litigators, we have still more to learn about how best to do that. But I won't, given the time, I won't say anything more. Thank you to Anirudh for chairing. Thank you to Floris and Clara, and do look at the recordings of the other webinars. Thank you very much indeed for joining us.
Thanks all. Good evening.
Thank you.
Thank you.